Hey everybody, I'm bringing you an easy one today. Rear end collision. Who's at fault? Driver in back, right? Not always. That's the general rule, and there are really good reasons that that's the general rule. We'll talk about those in this video, but we're also going to talk about some of the exceptions to the rule. When does that rule not apply and why? And why are there good reasons for exceptions as well? My name is Vern Ready with Ready Law. I'm an injury lawyer practicing in the Denver, Colorado area. And today we're going to talk about the exceptions to this rule and why the rule exists. And let's start with that. Why is the rule that the driver behind is usually at fault in a rear end collision? We all trust the drivers behind us to maintain a safe distance. That's up to the driver behind us. It's not up to us. We can't control whether someone else behind us is tailgating. We can't control the amount of space that they decide is a safe space. So the law just does that for us, or does its best to, by making sure that everyone understands that they have an obligation to maintain a safe distance from the vehicle in front of them, starting with, chapter 1 of the driver's ed book that teenagers are relying on when they go to get their license. We all know that the driver behind has all of the control when it comes to the question of how much distance is a safe distance for the speed and the conditions and the circumstances at the time. And all of us have to trust the driver behind us to make the right decision when it comes to that. So that when there's not enough distance between vehicles because the driver behind is following too closely, that driver is gambling with our safety and our health and well-being. And so they're responsible for the consequences of that when they guess wrong and they don't leave enough space to safely stop their car if something happens where there's a sudden or unexpected stop. So the fact that it's a sudden stop does not let the driver behind off the hook. It doesn't change their obligation to maintain a safe distance. Because the whole reason we're maintaining a safe distance is because we expect that something unexpected might happen, that wildlife might dart out across the road. Anything. It could be anything. It could just be an unexpected slowdown in traffic that we don't see because we're not watching 4 or 5 cars ahead. We're leaving that safe distance because we understand, based on our driving experience and the law, that we have an obligation to the people in front of us to do that. So that's the general rule, and that's why that's the general rule. So when does the rule break, or when does it simply not apply? Let's talk exceptions to the general rule. Brake checking. This one's juicy. What brake checking is when someone pulls into traffic, whether because there's road rage going on or because they're intentionally trying to set up some sort of scam or fraud, but they pull in front of another driver and then slam on their brakes, trying to get the other driver to hit them or just give the driver behind some sort of stroke or heart attack because they're angry. It's extremely dangerous. It puts everybody involved at risk, including the scammer or the brake checker, and it causes collisions. And so obviously in that scenario, you have someone intentionally causing a rear end collision. The standard rule is not going to apply that it's always the fault of the driver behind. Now, what it comes down to then is just proof, evidence, because rarely does the person doing the brake checking admit to having done that. But the person behind, and this is why a lot of people want dash cams and use dash cams and rely on them to show what happened, the person behind is then going to have to explain what happened and why and how much of a safe distance they had allowed. But brake checking is one example where the driver behind, even though it is a rear end collision, is not at fault. The person who intentionally caused that collision would be found in almost every circumstance fully to blame for that. And I think intentionality in that scenario goes a long way in overriding the rule. There are other exceptions to the general rule that the car behind is at fault. One of the other exceptions, in addition to brake checking, is a sudden and arbitrary stop by the person in front. So brake checking is a sudden and intentional stop, but a sudden and arbitrary stop, meaning there's no reason for it. There's no explanation for it. The driver in front just misbehaved, and for whatever reason, in the middle of a freeway with no obstructions, suddenly stopped their vehicle. Now, this one is a little bit touchier. It's not as clear because it doesn't have that element of intentionality that brake checking does. And so this is probably going to come down to gathering evidence, gathering facts, and arguing them in the correct way to help a fact finder, meaning like whether it's a jury in a jury trial or even an insurance adjuster, understand all of the factors that went into this, because what this all is going to come down to is a reasonableness decision. Why did the driver in front stop suddenly and unexpectedly? Why did the driver behind not have enough space between the vehicles to come to a safe stop, even though the driver in front did something unreasonable? This is one of those scenarios where you might encounter what we call comparative negligence or comparative fault. In Colorado, it does vary state to state. The rules are different. But in Colorado, just to provide an example, it is possible for the negligence decision, the who's at fault decision, to come down to a question of reasonableness and be divided between both parties. It might come down to a question of, well, maybe the driver in back was 40% at fault and the driver in front was 60. Or the other way around, where the driver in back was really a little bit more at fault because they were just following too closely, even though the driver in front did something unexpected and unexplainable. There are a lot of ways that that could fall. And so you can kind of see where it's not such a clear-cut question in every scenario that it was a rear-end collision. Oh, that's easy. The driver behind is at fault. Another common scenario in rear-end collisions is a chain reaction. If multiple vehicles stopped, say at a red light, and someone comes up and slams into the back of the rear car, pushing it forward into the car in front of it, and then that car can even be pushed forward into the car in front of it. So you have multiple claims here against multiple drivers. Who's at fault? It's sometimes not completely straightforward. It's not a one-size-fits-all answer, but you can imagine how difficult it would be to argue that someone didn't reasonably and safely stop because they failed to anticipate a chain reaction of rear-end collisions. It's not something we anticipate in our normal day-to-day drive. So typically what we have found in our experiences, it is the car that caused the initial collision, pushing other cars into other cars, that is going to be liable for the whole thing. We've talked about a general rule. We've talked about exceptions to the general rule. But how do we decide who's at fault? We try to guess what a jury's going to do. Even insurance companies, when they're trying to decide how much to pay out on a claim, they have, in some way, in the back of their minds or in the front of their minds, what would a jury do in this circumstance? Well, what's the standard that we give the jury when it's time for them to decide who's at fault? In almost every state, it's different state to state, but in almost every state, it really just comes down to reasonableness. Did someone behave in a way that was reasonable? Did someone behave in a way that was unreasonable? And sometimes, in some states, including Colorado, that can even be divided between the parties involved in the collision. So maybe more than one party was unreasonable. So what percentage total is assigned to each of them? And what we call here in Colorado, comparative negligence. We're going to do a whole video on comparative negligence. We'll explain it. We'll explain how it works here in Colorado and what the rules around it are and how those come out. So check that out when we post it. But for now, you just need to know that it comes down to a determination of who was reasonable, who was unreasonable, and if more than one party was unreasonable, it can be divided among them. What do you need to know about that decision and how it can be applied throughout a claim for injuries that arise from a rear-end collision? Well, what you need to know is that the insurance company knows how it works, and they may be applying that in your claim without you even knowing. That part that I just covered about comparative negligence and the insurance company assigning a percent of blame or fault for a collision. In our experience with advocating for people who've been injured and are trying to recover compensation from an insurance company through an insurance claim, we have seen many, many times when auto insurance companies will actually assign a percentage of fault or blame to our clients when they weren't negligent at all. 0% negligent. And the insurance company will arbitrarily assign a percentage of blame or fault to our client. And that's really important to know, because what it means is they will also reduce the amount of the insurance claim payout by that amount. So if they conclude on their side of things that our client was 10% liable or 10% at fault in some collision, including a rear-end collision that just has weird or odd circumstances, then that means they're going to pay 10% less on the claim. Of course, that's a self-serving decision. It benefits the insurance company, and that's why it's important that you know when it happens and that you know what it's based on. And if you have an advocate, a lawyer who handles these kinds of cases day in and day out, then they can identify that and they can make arguments about it. It all comes down to reasonableness, and you need someone in your corner to argue for reasonableness. If this is something that you're trying to do yourself, So even in these questions that seem like they should be simple, who's at fault in a rear-end collision, things don't always come out exactly the way you might expect them to. Experienced advocates know that, they have experience with it, and they can help guide you through the process. Reach out, get help when you need it. We're going to tackle some of these issues one video at a time, so subscribe to make sure you get them. But we're available right now to help anyone in Colorado get ready.